Every day in the USA, people find themselves in court.
Matter of Todd Lemon versus Falcon Custom Homes, case number 24-11840-CK. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on plaintiff's motion to compel and for sanctions.
Your Honor, I can.
All right, well, let's proceed with this motion. This is first initial matter. Counsel, why don't you place your appearances on the record?
Good morning, Your Honor. Herman Hoffman with Farnham on behalf of Todd and Lori Lemon.
Thank you.
Good morning, Your Honor. Matt Tom. Sorry, go ahead, Mark.
If the court please, Your Honor, Mark Hills on behalf of defendants, Falcon Custom Homes and Nathan Abbott.
Very good. Thank you, Mr. Hills.
Good morning, Your Honor. Matt Tompkins here for the defendants as well.
All right. Thank you, Mr. Tompkins. And with that, I have read the briefing here. Let's move on to the documents here. First one being the an Excel spreadsheet.
Thank you, Your Honor. And so on the Excel spreadsheet, that was something that was encompassed by our discovery requests.
Well, if I can just pause you, Mr. Alvin, I did glance at the copy of it you provided, and it looks to me like the dates on there all precede the date range in your discovery request.
Well, the document itself doesn't have a date, Your Honor. It has.
Well, I'm just looking at the entries, I guess.
Right.
Right. In there. Right. I understand. Yeah. There's no header on the document that says which day it was created. So,
Right.
But I guess the question would be, why would, if I'm responding, why would I say, oh, I'll just toss this in there? Because I understand it might help you if they did that, but why would a lawyer look at something that didn't have dates encompassed, or it looks to me like also maybe not the project, it doesn't look like your specific project's one of the columns here.
That I don't know, Your Honor, because they've blacked out the names of every project. So
yeah, you just got the subs names, not the project names, although there wouldn't be very good reason to block out Falcon if Falcon was one of them, but the dates on here wouldn't appear because this bill doesn't start till 21, right?
Right. So so number one, the document itself is a living document. Their witness testified she would update it continuously, and I don't know if my client's name is on there because they've blacked out the project names, but here's why the document is important. I mean, it's it shows, number one, intent and knowledge that defendants knew exactly what they were doing when they were defrauding my clients because they had done it before. So that's important. And number two, it also helps, it's relevant to my client's damages. It shows how the defendants calculated these percentages that they had their subcontractors mark up. It shows what percentages they used, and it shows which subcontractors participated in this. And the fact, even assuming, let's assume for the sake of argument, which is not at all been established, let's assume it only relates to projects before 2021. Then it's also relevant because it shows that the scheme here, that defendants implemented with my client, was something that they had done before. It's something that they knew exactly how to do. And so they brought this well-oiled machine to bear on my client's project when they signed their contract in 2021. So it's highly relevant to our claims, and beyond the redaction, Your Honor, the way they've produced it, and Your Honor is probably familiar with what happens when you print or you convert to a PDF, an Excel spreadsheet. It's completely a disorganized mess now that makes it very hard to present to a jury or to Your Honor as to what it means, because it used to be a spreadsheet, or it is still a spreadsheet, and they've printed it as a PDF, and so it's completely messed everything up. and maybe our motion could have been clearer on this, or our brief could have been clearer on this, but there's also other documents in this folder that's on OneDrive that we've also moved to compel and that we don't have. So the testimony of Mrs. Zandbergen was that there was this spreadsheet and there were other documents in that folder, including checks that they had received from subcontractors. Those haven't been produced either. So those were all encompassed by our requests, and they're also encompassed and mentioned. We mentioned them in our motion. So I just wanted to clarify that.
Okay, and your argument there would be for the reasons you just presented. I guess on one hand you say, okay, I'm trying to prove up a rebate or kickback theory at trial. I've got Ms. Zandbergen's testimony that perhaps this happened in the past. It wasn't clear to me. I did read the portions of her depth that you excerpted, and she was less than crystal clear on her timekeeping, or on how long she'd kept this record, other than the fact that there was a folder. And we're talking all about electronic. She scanned the checks in and then also made the entries on the spreadsheet, supposedly.
Yes, Ron.
Okay, all right. And so we're talking about a folder that exists, and presumably where the document came from is a printout of an electronic record.
That's correct, Your Honor.
Okay, all right. I think I understand what you're asking for, and let me hear from the defendants on the matter.
Thank you, Your Honor. I'll kick it off. Firstly, the spreadsheets are clearly unrelated to this project. That's one. Two, they're beyond the scope of Mr. Hoffman's personalized limitations for his discovery request. So, and another point, Your Honor.
Well, I guess with the redactions is, how does he know, you didn't redact the stuff from 2021 that says, the plaintiff's names on it. Did you give him a privilege log?
No, all that was for a couple things, Your Honor. One, we produced them in the spirit of discovery, even though they weren't asked. Second of all, the only thing that was redacted were the last names of the owners of the project. That's it.
Okay.
And Ms. Zandbergen said that she had an understanding that these documents existed. She didn't have any role in finances at all during these projects that predate the Lemon project. So we didn't know
the finance person at
no, not until mid 2021, okay. Your Honor. And so these all predate that. Mr. Hoffman's trying to rewrite his own discovery request and singularly obtain the benefit of document production, despite the fact that we've asked to extend the discovery period globally multiple times and it's been rejected. So he's asked for these documents that predate his own limitations. We've produced, in the spirit of discovery, documents that were redacted to take names out of from projects that we've done on thousands of other documents in the course of this litigation and never gotten objections to. That's that piece, Your Honor. So I can't even fathom how this would even be, one, something that's producible, and then two, how in the world it would justify an award of sanctions when, to be honest, we didn't even know these things existed, and I don't think Ms. Zandbergen had any clue that there was any relevance to these documents, and I don't think there is. So that's our position, Your Honor.
Okay, and that would encompass the production of it in its native form. I mean, after all, if I do determine that this is encompassed by the discovery request or a reasonable interpretation of the discovery request, then I can require it in native form, the native form being a native, I guess, Excel, or I think she did testify it was an Excel spreadsheet. And of course, the advantage of that is then Mr. Hoffman can look at that, including its embedded, data, and determine whether or not it's been altered and who made those alterations and on what date, and possibly springboard off that to, establish a greater degree of relevance. And I suppose that would possibly, if they have this was printed from their electronic file. So as far as they still have the original spreadsheet in an Excel format.
I would imagine, Your Honor. The issue, and this is giving myself way too much credit. I have no clue how to doctor up these things at all. Certainly couldn't have the wherewithal to change anything or the knowledge. I guess my concern with producing in native form is how do we redact the names of the project owners? Because that's the concern is that these folks are solicited for lawsuits against my client, which we've had motion practice on before, and is wholly irrelevant to this proceeding.
Well, I think we have a protective order in place, right? Don't we have
We
a
do.
stipulated protective order to prevent that? So,
But that's been breached because Mr. Hoffman has reached out to other project owners soliciting their business. So that's clearly what's happening here.
all right. Well, let me hear from Mr. Hills, and then I'll go back to Mr. Hoffman. You're muted, Mr. Hills.
My apologies, Judge. I simply was going to say, well, Mr. Tompkins has more than appropriately covered that topic.
Okay, thank you. All right, I'll go back to Mr. Hoffman.
Thank you, Your Honor. Just wanted to clarify, Miss Zandbergen is the bookkeeper of Falcon. She was the
Current
bookkeeper.
bookkeeper. Does she go back? When did she start doing that?
I don't remember off the top of my head, Your Honor, but it was before the Lemon Project. I do know she was there before the Lemon Project, even before 2021.
As bookkeeper, or did she have a different role?
As bookkeeper.
Okay.
That was her testimony, and she was obviously aware of this spreadsheet, as was Mr. Carpenter, who also mentioned it in his deposition, and they brought it up, so they clearly thought
Carpenter's role.
he was the former co-owner of Falcon with Nate.
Yeah.
Yeah, and Miss Zandbergen brought it up, and so she clearly thought it was relevant. And again, the important part, Your Honor, here is this is a living document. That's what Miss Zandbergen's testimony was. That was updated as these payments were received, and so if just because some of the entries on there or the entries that I can see are have dates before the project, doesn't mean this wasn't encompassed by the discovery requests. I mean, there's lots of documents that are very important to this case that are living documents too. They've been produced before. I mean, and they may have been created for the first time back before 2021, but that doesn't mean that they're still not relevant to this case. And the relevance again is that it's part of this scheme. It shows that this was something they put into place and used before my clients, and so when they brought it to bear on my client's project, it was a well-oiled machine. I mean, I really don't understand how defendants could even claim it's not relevant to this case when it's the very case. One of the main claims is this kickback scheme, and that's what this Excel spreadsheet tracks.
Well, I get it, and certainly I think you probably got what you need if you're going to go in there and say, hey, look at folks, this is a new practice for them or unique to this build. This happened before. Let's hear from Miss Zandbergen and see what they have produced, the spreadsheet indicating what you're going to characterize as a kickback scheme. They're going to characterize as a rebate scheme, but nonetheless, I think I understand where you're coming from. Well, I am a little less convinced that you are, Mr. Hoffman, that this is the ultimate smoking gun here in the form of this spreadsheet, because it appears, at least from the document produced with your motion and in response to this information given by Ms. Zandbergen, that the entries on this predated and perhaps didn't continue through the date of the project. Now, it might be valuable as is to show some pattern in practice. However, you don't know what you don't know, and part of that is that you are entitled to the document in its native form. So I will grant the motion in part and order that the Excel spreadsheet that is attached, I think it's to Mr. Hoffman's brief as exhibit, I have that as V on your brief, be produced in native form within 14 days. And that is in its original Excel format. It has more than, what I'm going to describe as tangential relevance. I think there's enough here for Mr. Hoffman to argue already that, boy, this happened before my client, and here's the evidence of that. On the other hand, you know, for whatever reason, the record doesn't appear to extend through the date. So native document within 14 days, that'll be before the date of the deposition. So Mr. Hoffman can take a look at it and hopefully have some one computer guru also take a look at it and see if there's anything that needs to be further explored during Mr. Abbott's deposition. And I'm not going to award any sanctions on that. Again, here I view this as a document that, because of its date range, that at least it's apparent to the court now, would not necessarily be encompassed by the original discovery request, which of course, has its data starting the date of the project. So I'm not going to award sanctions for that reason. Let's move on to the final piece, which is this valuation of the project in terms of it looks, what appears to be a split of the partnership at some point. Mr. Hoffman, why don't you elaborate?
Thank you. And just to clarify, before I forget, Your Honor, on the Excel spreadsheet, would that be 14 days from today so I can have it sufficiently in advance of the deposition?
That's correct.
On the appraisal, Your Honor, again, our requests for production of documents did encompass this document. Just some examples I'll give the court. Request number 25 requested for all Falcon projections of costs for the Lemon project. Request number 29 requested all internal Falcon documents related to the project. Requests 35 and 36, all documents or other files which discussed or related to the Lemons, which mentioned the Lemons. And so this document was encompassed by our request for production of documents, contrary to what defendants are arguing here.
And just to pause you, your request for production would be directed both, of course, to the corporation, to Falcon, and to Nathan Abbott individually, because it appears that, the document that was referenced by his former partner, probably was most useful in terms of, doing a breakup of their partnership at some point, at which they had to do evaluation of projects. Is that a fair characterization?
That's correct, Your Honor. Our requests were directed to both defendants.
Sure. And so even if Falcon's going to say, well, corporation didn't have any record of that, we just did our corporation thing, Mr. Abbott certainly arguably would have the record because obviously his financial interests were directly implicated there. So
that's correct. And this document is it's part of Falcon. It's in Nate Abbott's personal possession. Mr. Carpenter, again, the former co-owner of Falcon, he testified that Falcon's CPA was involved in this appraisal as well. And so certainly it's within the possession or control of many different people here. Counsel for Nathan Abbott was involved. Counsel for Dustin Carpenter was involved. I mean, a lot of people had their hands on this appraisal, which Mr. Carpenter testified to unequivocally that it included a valuation of the Lemon project. And this happened very soon after, or right around the time that defendants, both Falcon and Mr. Abbott, were representing to my client, both in the contract and outside of and before the contract, that they could build this house for the Lemons at an estimated cost of 6.3 to 6.7 million. And so right around the time, both before and after they were making those representations to my client, they were conducting this appraisal of Falcon's business, which included their valuation of the Lemon project, which was their internal estimate of what the project would actually cost. And so
Sure.
this
And if
was,
that comes out and says, they're really valuing it at $14 million, then you're going to stand in front of the jury and say, folks, they intended to, extract extra money out of the lemons all along. And here's a document that says as much from objective source, possibly. All right. I think I understand what you're looking for. Let me turn to defense counsel.
Thank you, Your Honor. First off, the first that we'd heard, we being defense counsel, I think I can speak for Mr. Hills, that there was ever a negotiated resolution that specifically included valuing ongoing projects was at Mr. Carpenter's deposition. We've never seen any type of documentation. That was never disclosed to us that it even existed. And I think it's important. I think that there is a presumption by Mr. Hoffman that these documents, one, exist, and two, that they say what he thinks they say. Mr. Carpenter made clear that these were all negotiations, that they were negotiating their divorce, if you will, from the company, or Mr. Carpenter's decoupling from the company, and that he was, I'll use the word irritated with Mr. Abbott's position on what he thought the value of the Lemon project was, because it would be less of a calculus to going into the whatever payout Mr. Carpenter would receive ultimately, negotiated presumably by their lawyers that handle that piece of this. So it seems completely irrelevant to this lawsuit, Your Honor. I mean, Mr. Carpenter testified to that this process took place. I'm sure Mr. Hoffman's going to ask Mr. Abbott about it. So there's no effort to try to hide the ball here. We just think it's completely irrelevant because any number was generated as a negotiation for settlement.
Sure, but if there's, usually in such things, there's some objective basis for it. It's not necessarily going to be just Mr. Abbott saying, I think it's worth X, Y, Z, but rather, there's going to be some calculus or agreed upon, method of valuing. Certainly, I think what Mr. Hoffman's saying there, if that value looked to them from an objective source, from a third party, be it a CPA or a, business what are the appraisal, the appraisers out there that do business valuation, their perspective, that it was higher and comes in like that. He's got an argument to say, well, at very least, that was the point that, Mr. Abbott and Falcon should have approached the Lemons and said, hey, look, folks, I know initially we said 6 million, but it's going to be twice that. I guess it strikes me as something that very well could be relevant. And I guess then the second question is, is this something that's currently in the possession of Mr. Abbott that can be produced? And if there are privileged things in there, because certainly if it's, created by an accountant and a lawyer, there are privilege arguments. And of course, their anticipation of litigation, they're anticipating potential litigation about the separation of the partnership, not this litigation. So you have to be careful about the, definition of work product there. But nonetheless, I guess I'm trying to get a handle on how easily you can get your hands, or Mr. Hills, or the both of you, on the document, whatever exists out there.
Yeah, I'll start. I don't even. It's a
You
fair
haven't
point,
seen
Your
it.
Honor. I have not. We have no
I gathered
idea.
that.
Yeah. So we certainly will do whatever the court orders in that regard to try to conduct due diligence to try to find this document if it in fact exists. We have not done so because for all the reasons we already discussed. But I can't really give the court a really good answer on how long it will take to produce it. Is the point.
Okay. All right. Let me hear from Mr. Hills if he's got any insight.
Thank you, Your Honor. First of all, echo Mr. Thompson's comments. I've never seen, or Tompkins' comments. I've never seen the document. And given our position, we made no effort to figure out what its, I guess, portability is or current existence is. I think, Judge, the record needs to be accurately represented to the court. What Mr. Carpenter said at his deposition was that as part of the accountant's work, in determining a value of the overall company, not of any particular project, etc., they reviewed certain matters, and given the relative youth of this particular project, contract signed in January, staking in April, at the point in time roughly when this valuation was being completed, the accountant simply used the face value of the estimate. There was no specific analysis or determination undertaken, which gets us then to a very important point relative to plaintiff's claims, because Falcon did not prepare the estimate. The record is clear from deposition that the estimate was prepared by the Lemons architect, independent of Falcon.
Sure. No, and I get it. I
It's
guess
very clear that there is no representation that the home can be built for that price. It's in the face of the document. So to suggest that that is somehow something that is then going to bind Falcon is both contrary to fact in the sense of the source of the estimate and contrary to the very specific terms of the contract document, which speak for themselves loudly and clearly. So this idea of then an accountant takes that document and says, well, the project's so new, the only thing I can do is use the face value of it as one of many factors in trying to determine the overall value of Falcon Custom Homes for purposes of negotiation between its two principals, gets so far outside both relevancy and the proportionality of this case to mean that the document should simply be left where it is.
Yeah, no, I get the argument. However, proportionality, after all, we are talking about a multi-million-dollar case here. And, secondarily, there is evidence, at least Mr. Carpenter seems to think that those appraisals prepared in anticipation of the breakup of the partnership did include a by-project analysis. Now, I guess in your case, for Mr. Hills and Mr. Tompkins, your best case scenario is the accountant just takes the same number that was put out there by the architect, and that makes its way into the appraisal. And even though the two owners may not have agreed on it, but I'd agree that that's probably not relevant very much. Nonetheless, the numbers would be consistent. However, if the number comes down because of whatever inputs and it comes out that it's much higher than the original architect's estimate, well, then, there may be something to talk about. And of course, without seeing the document, no one knows what that looks like. So what I will do
But
here
respectfully, Your Honor, that would be true as it relates to representations from Falcon to the Lemons. The document doesn't involve any kind of a representation of that sort. It's simply an acknowledgement of the existence of a contract with an estimated price in it.
Right, but of course
It doesn't create a starting point for the analysis of whether the project should have been estimated at 6.3 or 15.5. That has nothing to do with the valuation process of Falcon, the entity.
No, but I agree. But I think what
when-
I'm saying though is that Falcon, the entity, values it much higher than the estimate, then at least creates an argument that at some point they knew or should have known that the cost of continuing with the build was going to be much higher than the starting point of the estimate, with all limitations. And I see what you're saying is that may not be the binding. It's really an evidentiary question, but we're not talking about evidence right now. We're talking about discovery. I do think under the broad definition of relevant or potentially lead to relevant evidence, that the document could be relevant. So what I'm going to do is order production of the document itself, or a statement that no document exists any longer within the 14 days. And to be specific about the document I'm ordering, is going to be a document containing the appraisal of the specific Lemon project for the purpose of the business valuation pursuant to the separation of the partners, Mr. Carpenter and Mr. Abbott. What I'm hoping to do here is have Mr. Abbott, who I suspect, along with most commercial litigation clients, may not have taken as fine tooth comb is hoped for by the attorneys through his records is going to look through this again and say, oh yeah, I did have that somewhere. Here it is. It may be, as true with the spreadsheet, a non sequitur at that point when it gets produced, but from Mr. Hoffman's perspective, of course, he doesn't know what he doesn't know, and it would be very helpful to know, I think, if there are questions to be asked, they're probably to be directed at Mr. Abbott at his deposition. So that's why I'm putting a relatively short fuse on it, would be to get it to Mr. Hoffman at least far enough in advance of that deposition date that he could then question Mr. Abbott on the contents of that. So,
Well, so we're clear, Your Honor. Again, I apologize for interrupting, but as the court noted in the beginning of its comments on this topic, that document, I can't speak to it because I haven't seen it, but I suspect it contains an awful lot of information that may be subject to several privileges, but separate. Even if it's not subject to several privileges, it likely contains an awful lot of information that is entirely irrelevant to this proceeding, that relates to the business practices of of Falcon Custom Homes, to its clientele, et cetera, none of which would be relevant to this proceeding. So what level of redaction is the court contemplating that it will allow Falcon to exercise?
yeah, any redaction should be recorded and labeled on a corresponding privilege log as to the basis for the redaction, and we'll produce that. Should be doable since we're only talking about what seems to me to be one document. And given the hundreds of thousands produced in this case, I can't envision this one being enormously long, so it ought to be doable, providing, of course, it can be located at all, which is really the starting point for this inquiry. So.
Understood. Thank you, Judge.
All right, Mr. Hoffman, you'll write up an order and get it over to me?
Yes, Your Honor.
All right. Thank you, gentlemen. I'll look for the order and appreciate the efforts to keep this thing on track.
Have a good weekend.
Good weekend, all.
Todd Lemon versus Welcome Custom Homes, you know the case. Got a motion to compel, sanctions all over the place. Hoffman's on the line, says they're obstructing the depot dates. Hills pushed his client's phone, guess Abbott just had to wait. Something about a spreadsheet that predates the whole project. Then an appraisal shows up, now that's a document to inspect. Judge Ross keeps it moving, sets a deadline for the production. 14 days for that native exil. No more obstruction, now the train's back on track. Discovery's extended through May. Falcon and Abbott gotta produce, that's what the judge had to say.
We are here in the matter of Todd Lemon versus Falcom Custom Homes, case number 24-11840-CK. This hearing is being recorded on Zoom and live streamed on YouTube.
All right. Well, let's take these in order. I think that plaintiffs was filed one day earlier. So, Mr. Hoffman, that's going to be you to lead us off on this matter. And your have reviewed the briefing, and it seems like, the portion that you're most interested in here is me granting you summary disposition under the breach of contract action, specifically to return the $316,622 construction deposit. And I believe that is... did I state that accurately? Is that right, or didn't I get it all, Mr. Hoffman?
That is correct, Your Honor. That's the subject of our motion for partial summary disposition.
Okay, very good. No, thank you. I will let you proceed, but let me ask you a question first. I did review the briefing and included somewhere along the ways, I believe, in fact, in the responsive brief from defendants, was the fact that Mr. Abbott says, well, wait a minute, I've got some bills that aren't paid. These are the sort of things that, in his estimation, would be paid, apparently out of perhaps that, if not satisfied, directly by a payment. And I know you haven't had the opportunity to depose Mr. Abbott yet. What should I do with regard to that affidavit and the facts stated therein?
Sure. Thank you, Your Honor. And so I just want to highlight for the court, a few things that they don't dispute in their brief, and that's that, we all agree the deposit was paid. We all agree that the contractual conditions, warranting its return, those have been met. and they don't argue for a different interpretation of the deposit provision in the contract than we do. And
And
they're
if I
only
can
arguing.
pause you, Mr. Hoffman, the contractual conditions include completion of the punch list. And I guess arguably here, perhaps because the parties' relationship soured, as it were, perhaps before the final punch list was ever done, there may not be agreement on whether or not the final punch list was ultimately fulfilled. But it appears that there's what I would view as maybe a superseding provision that says, oh, by the way, though, if you get a certificate of occupancy, and I don't know, in building world, does that always happen that a certificate of occupancy is always after the final punch list, or are there occasions where you get one of those and you still have a punch list?
There can be occasions where you get one of those and still have the punch list outstanding, certainly. And so that is true. The punch list was not completed, and that is on defendant. I mean, if they, this punch, according to the contract, there was a punch list, and their responsibility was to complete it, and that punch list invoice was the only invoice that could be set off against the deposit according to the contract, the governing contractual provision here. And so that doesn't help them at all, in my view. I don't see how it could possibly help them because no punch list was completed, and so there aren't any punch list costs they incurred. So there can be no set off.
There's no world in which, for example, I take this in light most favorable to defendant, and you lose on every single imaginable claim here, and we reset this to the way things were 2 years ago, and we say, oh, by the way, there's still this punch list, and you should do it, and then we'll fork over the rest of the money. That's because of the, and I think that if the agreement's been breached is a little bit of an understatement when you get this far in litigation, but that's just not a possibility.
That's right. I don't see any. They have not brought a counterclaim, saying that we owe them any money here, and this set off that they're claiming, that's an affirmative defense that they have the burden of proving, and in setting all of that aside, let's set all of that aside, which I think is all undisputed. But let's set all of that aside and let's just focus on their argument, which is that there's some unidentified amount out there that is the subject of some unidentified invoice that we might possibly owe. The Michigan court rules and the case law that we have cited make clear that set off is an affirmative defense that they have to provide evidence for. If they are going to respond to our summary disposition motion with an affidavit, then they have to provide specific, particularized evidence supporting it, and they haven't done so. All they have in this affidavit is that my client might owe them some unidentified payment based on some unidentified work that's been done, and they don't even cite an invoice. They don't cite an invoice number. They don't cite an amount. They don't talk about what the work could possibly be. They don't attach an invoice. They don't attach an accounts receivable ledger. They don't attach any account statement. All they have is a conclusory, non-specific affidavit and we've cited I don't know how many cases and quoted in our reply brief, all saying, which is the clear case law, that a conclusory affidavit is insufficient to create a genuine question of material fact. And so this, otherwise, Your Honor, anytime a party filed a summary disposition motion, the other side could, respond with an affidavit saying, oh, they owe us some money. they owe us money. We don't owe them money. And then there would always be a question of fact. But the courts have made clear that in order to overcome a summary disposition motion, a party needs to provide evidence supporting a question of material fact. And if they're going to attach an affidavit, it has to be specific, and it has to provide for particularized evidence disputing the question at issue. And they have not done that here. Their affidavit does not get them there. They also attach this expert report of Michael Kahane. And I'd encourage the court to look at pages 13 and their exhibit D, and also page 14 and exhibit C of that expert report specifically. And I'm just going to quote some of the opinions that Mr. Kahane says there, because what the court will see is that he agrees with plaintiffs that plaintiffs are owed money back here. That's his opinion, and it's his opinion under multiple scenarios. So, for example, I'm quoting his expert opinion at page 13. I determined that the total adjusted invoice amount under scenario 1 is approximately $17.01 million. Project records detail that the Lemons paid approximately $17.18 million to defendants, resulting in an overpayment of approximately no more than $163,000. So there he's saying his opinion is that
your
there was
clients have overpaid already, right, by that amount, and then scenario 2 looks like he overpaid by 186. So I tabbed that as well when you pointed me towards that in your brief. That right, under every situation analyzed by their expert, at least, there's a concession that Falcon was overpaid. Ergo, the remainder of the money would be available, with the potential exception that maybe the expert didn't review, some of these mystery invoices that are referred to by Mr. Abbott.
Well, and Your Honor, the defendant's discovery right has closed. We have discovery open to take Mr. Abbott's deposition yet, but we also sent, and we attached those to our summary disposition brief. We sent defendant interrogatories asking them to identify for us any invoices that remain unpaid, asking them to identify any amounts that remain unpaid, and they didn't do so. They had the opportunity to do so. They didn't do so. Discovery has now closed. And so there is nothing for them to go to the jury with. They haven't identified it in discovery. They haven't identified it in response to our summary disposition motion. And so there's no question of material fact here. And the best they can do is provide an affidavit that has no particularized facts in it. All it says is, that we somehow owe them some unidentified payment. And the last thing, Your Honor, is they attached their new complaint that they filed after our summary disposition motion was filed. And a couple points in response to that. Again, it's well established, the case law, that they have the burden to go beyond the pleadings at this point. That's a new pleading. The party cannot rely on a pleading anymore. It's not evidence, and it's also not. It's not competent summary judgment evidence. Evidence is just allegations that were drafted by their attorney. They can't file a separate lawsuit, which I think was a litigation tactic here on their part, and then point to that lawsuit as somehow evidence that would be responding to our summary disposition motion here. And it's irrelevant anyways, because it's not about the deposit either. And finally, Your Honor, again, to the extent they're going to claim at this hearing, and as they did in their response, that, we'll come up later with some invoice or we'll find it later somewhere, courts have made clear that that's not a valid argument at summary disposition anymore. They can't say that, evidence might show up later. And they'll just point out too that this hearing has been pushed back a couple times to allow for additional discovery. And so there's been much time for them to do the work. They were supposed to do the work before. And at this point, speculation and a promise to come up with something later is not enough.
Very good. No, I think I understand your argument. Let me turn to Mr. Tompkins.
Thank you, Your Honor. I'll start with Mr. Cahayan's report. The flaw with Mr. Hoffman's utilization of that report as a cudgel is the fact that there hasn't been any final invoicing here. So obviously, Mr. Cahayan did not have that information to be factored into his opinions. So I don't see how that
could just pause you. Why in the world, when we're 2 years into litigation, or a year and a half, or whatever we are here into litigation, it's pretty darn clear this isn't going to resolve in a amicable, let's just pay the bill and get on with life thing. Why in the world hasn't that invoice been assembled and submitted?
First of all, at the stage that the project was at the time suit was filed, it was at that stage of doing punch lists and final invoicing. The problem is once suit was filed, they could not do that work nor develop a final punch list. So that's why it's not been done, because the work hasn't been done. And if you look at,
well, if the work hasn't been done, then they're in an invoice, right?
There's actually work that was not invoiced at that point, Your Honor. And I think
so some work's done, some work might have been on a punch list, and your statement today is what we're talking about is the some work that got done but never got reduced to an invoice because of delays in finalizing the punch list in this litigation that we're currently immersed in.
Partly, Your Honor. And the other point to dovetail off that is that if you look at the contract and looking at the briefing from the plaintiff, the condition preceding or the predicate for the payment or the return of the deposit is there being a final invoice, and that clearly hasn't happened here. That's it. I believe it's section 3.1 of the agreement. Any unused contract phase deposit shall be refunded to the owner upon issuance of the final bill. That's one. And then you use that and read that in conjunction with Mr. Abbott's affidavit, which if Mr. Hoffman's view of the world is that that's completely insufficient to create any type of a factual issue, I would strongly disagree, because what Mr. Abbott's affidavit clearly says is that there hasn't been final invoicing. So that is the provision in the contract that has not been met for repayment of the deposit. If you believe plaintiff's construction loss expert, the punch list, if you will, totals over $1 million in cost, which clearly would subsume the amount of the $316,000 deposit. So
when
that's
he's
our
talking
position.
about the punch list, is he talking about undone stuff or stuff that's already been completed and not paid?
I think both, Your Honor.
Yeah, well, right. I mean, punch list, and certainly the punch list in a project like this could encompass that whole $316,000. But I mean, is there really a world here where your guy thinks he's going to go back and fulfill that punch list and finish this project and split up the escrow or the deposit amount?
I can represent, Your Honor, that Mr. Hoffman has made multiple requests that happen as while this lawsuit's been pending. We've had conversations directly on that point. So there is a universe that may happen. And I think that the issue of the deposit has been in dispute since before the lawsuit was filed. And that was some of the email traffic that was exchanged between counsel before the suit was filed.
Yeah, no, I get it. But I mean, I guess at this point, you get to the nuts and bolts of it. I honestly think, the point you've litigated against each other for 2 years, I would say though nothing is impossible, the bridge gets burned at some point, and you say, okay, you know what, this isn't gonna be what everyone signed up for in the first place. We're not going to complete that final punch list. The final invoice is going to be if I've got work that was outstanding and not invoiced, that's the final invoice, and it's going to be submitted. And I guess what I'm hearing here is there is no invoice, that maybe there's work that's been done and there's a punch list that's to be done, but that final invoice not only has never been sent to, in the channels to the Abbotts for payment, but it hasn't been provided in the discovery of this case. Is that true as well?
It hasn't been generated, Your Honor. So it doesn't.
Yeah, well,
But
okay, then what's it based? There's some work that Abbott wrote notes about or documented, or how's he going to generate it?
Absolutely, and he's going to he's going to testify on April 27, I believe, is the date that we've talked about. So that's one piece of the puzzle. The other piece is that this is a breach of contract claim, and one of the claims relates to this deposit. That our position and our evidence is that it has not been breached as it relates to the repayment of the deposit, because there's been no final invoicing, because we couldn't issue one because of the litigation. Those are all issues that are clearly in dispute.
I guess I'm struggling to see why the existence of the litigation precluded issuance of a final invoice, at least up to, date of suit was filed. Here's what you owe me the last day before the lawsuit got filed here. And then, production of that and discovery, because we've been at this for a year and a half. I'm mystified as to why that wouldn't exist. I mean, if it's real.
Well, I don't think it's ever been developed fully, because we've not seen all the issues they're claiming that remain outstanding. One or two, what needs to be done work-wise. So it would be an incomplete invoice. It wouldn't be a final invoice.
Yeah, maybe we're getting hung up on linguistics here. It would be the final invoice submitted, because what I'm stuck with now, Mr. Tompkins, is I'm stuck with, Mr. Abbott's testified, hey, I paid the final invoice that was submitted to me, and here it is, and it says $0. I think at least what was sent to me, I paid in full. And it doesn't sound like you're necessarily disputing that Nathan Abbott paid the invoices sent to him in full. What you're saying is there's one more invoice out there that hasn't even been generated yet, because it maybe resides in your client's head. It's a little hard for me to get to what would be on that invoice. And you're going to learn about it in the future, and that would be the final invoice?
No, it would be a question for the jury to determine, Your Honor. That's what's at issue in this lawsuit, is what remains outstanding in part. And Mr. Hoffman points out multiple times that it's our burden of proof, and that's what we intend to prove.
But
we've not been given that
here against in this suit.
Not in this suit, no, Your Honor.
Yeah, I understand. There's a separate lawsuit where he's coming against it, but I do agree with Mr. Hoffman. That's notice pleading. That doesn't in any way fulfill the obligation. And I'm fully cognizant of the fact that although I recall I denied the addition of bringing the subs in, was the motion also to amend to add the counterclaim that I denied?
I don't believe so, Your Honor.
Yeah, I don't think so either. I think that's a new development. So, yeah, okay. Well, are there any other arguments? I get it. Okay, so you're saying, the contract language isn't done yet because, it anticipates a final invoice. Secondarily, there's this punch list, various punch lists floating around out there that haven't been fulfilled, and that theoretically might be fulfilled or might have been partly fulfilled already, and that there's still some money owed on that. And Mr. Hoffman, supposedly when he shows up for his deposition on the 27th of April, is going to elucidate everyone on how much money he thinks they still owe him.
I think that's the gist of it, Your Honor.
Okay, all right. Well, before the court is a motion for partial summary disposition. It concerns only the construction contract portion of this claim, and only a subset of the contract that required the Lemons, who contracted with Falcon Custom Homes and Mr. Nathan Abbott to construct a multi-million-dollar residence, and paid a 5% deposit of $316,622. Now, the contract itself anticipates when that uh, deposit is to be liquidated. Okay, this is section 3.1 of the agreement, at least discusses this, and it indicates that this is the referred to as the construction phase deposit in the contractual language, which both sides have cited and attached the contract. There doesn't appear to be any dispute about which contract applies here, or there are some disputes about which terms of the contract apply to it, but there aren't disputes about the actual document. And the document states that owner and builder shall perform a joint walkthrough inspection of the work and shall create a punch list. And I will state here, the court understands a punch list to be a list of things noted by either party during that final walkthrough that needs to still be done on the project, and they can run from the minor, this part, the paint didn't run all the way up to the edge of the door jamb, to the major, in that the windows are not of the quality that you promised me, and I think you need to replace every window in the house, and this house is all windows, so obviously at a very high cost. So the punch list, is to a degree a moving target generated by the parties of things that they agree upon need to be completed before finalization of the project. And this says puts the onus on the builder to complete the items shown on the punch list within 30 days after the creation of the punch list. Well, the argument here is that that never got done because this litigation intervened. However, and that paragraph goes on to say that there is, before that final joint walkthrough, which doesn't appear to the court necessarily, there were punch lists created, but I don't know that either party agrees that it was really the final joint walkthrough. I think this litigation intervened, that there would also be this scenario where the builder will prepare an invoice for the owner covering all work and materials invoiced to the builder since the last billing to owner, and including any unpaid invoices previously billed to owner, and this invoice shall be paid before the walkthrough inspection. Thus anticipating this final bill, a final bill will be prepared upon completion of the punch list, and the construction phase deposit will be applied against it. Any unused construction phase deposit shall be refunded to the owner upon issuance of the final bill. And then there is another provision here that indicates in there that another triggering event, if you will, for the refund of that deposit amount would be the issuance of the certificate of occupancy, to at least, again, the court's understanding, a collaborative effort of local building officials and the owner and construction company that get in there and say, hey, this house is sufficiently to code that people can live there. Now, obviously, that could, in some cases, precede the finalization of the punch list, because, as I said, those punch list items might not necessarily be the sort of things that would prevent occupancy of the house. But in any case, here it does appear, because the house has been lived in, that a certificate of occupancy was issued, but no punch list, inspection, or final invoice ever issued based on any of the punch lists that did exist. Now, it is also undisputed here that Mr. Lemon testified that in his mind, he did zero out his invoices, and that he paid the last invoice that he was aware of in full, and that it indicated on that invoice that there was a $0 balance remaining. And that was found in Mr. Lemon's deposition, I believe, page 67, lines 18 or no, I'm sorry, 22. That was, and then Mr. Lemon's testimony as well. Page 68. 9 and 10, and the Falcon 1024 invoice, which is attached to plaintiff's brief as Exhibit 22, listing total amount owed after application of credits as $0, indicating there is of record evidence in this case that Mr. Lemon can point to anyways that says, I paid this invoice entirely, received my certificate of occupancy. Therefore, Judge, the portion of the contract now requires return of that deposit. To counter that, Mr. Abbott relies upon an affidavit that he submitted prior to his deposition, which my understanding is scheduled for April 27. And that says that of course, that he is familiar with the construction project that is the subject of this lawsuit, and disagrees with, unsurprisingly, the motion for partial summary disposition, and states in number 6 of his affidavit the Lemons still owe Falcon payment on several invoices issued to them before the lawsuit started. Well, it appears that those don't exist. They would have been produced in discovery. So, at least one portion of Mr. Nathan Abbott's statement here is his affidavit, contradicts the facts that have been placed before the court. I haven't seen that unpaid I would think all the discovery that's been done here, if there was an unpaid invoice, it would be before the court today, and I simply don't see it. And there is another allegation, paragraph 7. In addition, because of the manner in which the Lemons fired Falcon and then quickly filed this lawsuit, Falcon has not yet invoiced the Lemons for significant work it had completed prior to that firing, for which payment is due under the contract. Well, and again, here, frustratingly vague in the significant work it's referring to. I'm sure that Mr. Abbott may testify about that, at the time of his deposition. But, as our courts have made clear, when you get to the summary disposition phase of a lawsuit, it is time to put up or shut up. And Mr. Abbott has simply failed to put anything up here as far as I can see. And frankly, if he testifies to it in the deposition, its credibility, as I said, would be low in the court's eyes and perhaps in jurors' eyes to potentially envisioning this. Number 8 says, further, Falcon is entitled to compensation for management fees that the Lemons withheld for certain completed work, which management fees were properly chargeable to the Lemons. Well, again, this would apparently refer to the agreed upon management fee and the cost plus contract that the parties entered into here. But as far as the evidence shows, the Lemons paid all their invoices and including those management fees. So again, there's a mystery management fee perhaps living in Mr. Abbott's head, unpaid, but there's no document reflecting that the court has seen anyway, produced during discovery in what has been a multi-$100,000, under $100,000 and page discovery type case here. So that just simply hasn't been done. So there, number 9 says, as a result, the Lemons have not paid the final invoice from Falcon and are not entitled to return of the construction deposit under the terms of the contract. Well, first of all, obviously, Mr. Abbott's not going to interpret the contract for the court. That's my job. And secondly, there is no invoice. If he had an invoice attached to his affidavit or perhaps had produced one during discovery, his statement would be much more credible. But as it is, there is simply nothing to back it up after voluminous document discovery in this case. So, and then he references his suit, but I do agree with the plaintiff in this case that suit, because it's notice pleadings. Well, of course, Mr. Abbott can say whatever he wants, but the time to produce stuff in this specific case is now. So therefore, I will grant the motion and order that the deposit be returned to counsel for Lemons within 30 days. And let's flip over to defendant's motion. First, the dismissal of the conversion action. Now, it occurs to me that the fact that I've ordered that money to go back, well, that was part, I would suppose, of what might be part of a conversion claim. The remaining part of it, as I understand it from your counter argument here, is, well, Judge, we're asking in this lawsuit to say that there was this kickback scheme and that monies got overpaid to subs and then subsequently returned to Abbott and Falcon. And in reality, Judge, those monies under the Michigan Builders Trust Fund Act, or I may have that set of initials wrong, were really all along the money that belonged to the Lemons and thus converted.
That's correct, Your Honor. The conversion claim concerns the kickback scheme, and really I like to say there's multiple kickback schemes here because there were different types of ways that Mr. Abbott and Falcon collected more and in different fees than what they were allowed to under the contract. But our conversion claim encompassed the kickback schemes and also the return of the deposit, although to the court's point, the return of the deposit was also the subject of the breach of contract claim, part of the breach of contract claim. And so what I'd say is there's two legal theories there.
Yeah, okay. And we're to the alleged kickback amounts now. And those,
Yep.
of course, are, significant as well. They're, variously identified. It looks like in both parties' experts' reports and estimated, that the parties are able to come up with numbers to attach to that. And that's the money we're talking about being subject to a conversion claim. Is it properly both statutory conversion in your argument and common law conversion, or just one of those?
It's both, Your Honor, and we've pled it in the complaint as both statutory and common law conversion.
Okay, what about that case law out there that essentially, let me flip to defendant's brief here, that says, well, it's actually statutory, so negotiable instruments, and this is 440.3420 sub 1, states that an action for conversion of an instrument, and I realize a check is an instrument, but a check represents a transfer of funds, so that could be the answer I'm looking for here, may not be brought by sub 1, the issuer or acceptor of the instrument. So, I think that goes to the argument that, okay, this check is transferred. It then becomes the property of Falcon and Abbott. They deposit it in their account. And that is totally subsumed, I guess, by a contract or a fraud action, perhaps, or for that matter, tort action. But nonetheless, is not subject to a conversion action. You disagree with that?
That's correct, Your Honor, because defendant's argument in that regard does not take into account the Michigan Builders Contract Fund Act, because that act creates a trust such that the monies that were paid by the Lemons here are considered a trust fund. They're held in trust for the owner, the subcontractors, and the laborers and other vendors. And defendants in their response cite the Michigan Builders Contract Fund Act, the second section of it. So they cite MCL 57152, but I would direct the court to the section before that, which is MCL 57151, which states.
Is this in your brief, Mr. Hoffman? I'm sorry, I'm flipping pages as I'm attempting to listen here. And I know you did cite that somewhere in here. I'm just as a loss as to which page.
Yeah, and I don't, we cited the Michigan Builders Contract Fund Act as to where we cited that specific provision.
I got you. Yeah, I'm making you do that. Gee, remember
It's
what you wrote down. I get stuck with that all the time.
yeah, it's page 11, page 10 and 11, where we cite MCL 57151. We don't quote that entire section,
Yes.
but we do cite it and discuss it. But I did want to just draw the court's attention to the specific language there. Again, I didn't quote it all in my brief, but what it says and what we did argue in our brief is that it says in the building construction industry, the building contract fund paid by any person to a contractor or by such person or contractor to a subcontractor shall be considered by this act to be a trust fund for the benefit of the person making the payment. And then it cites other, contractors, laborers, subcontractors, material men. And the contractor or subcontractor shall be considered the trustee of all funds so paid to him for building construction purposes. So that's MCL 57151. And so that act establishes that the funds that are paid by an owner to the contractor, your Falcon, are considered a trust fund, and that trust fund is for the benefit of the owner as well as the subcontractors, laborers, etc.
Does the statute specifically identify the owner as one of the beneficiaries, or is it just for the benefit of the subs?
It says, here's the specific language, for the benefit of the person making the payment.
Okay, yeah, who would presumably be the owner or whoever is paying for this project.
Yes. And that's the way courts have interpreted the Michigan Builders Contract Fund Act as well, is to create a trust fund in favor of the owners as well as the subs, laborers, material men.
Sure, and I look at it in its, perhaps a, more common application where you get this scenario where the purchaser pays the general contractor, the builder, and the builder hasn't paid a sub, and then the sub, puts a lien against the property, and the owner says to the, hey, where's, what's going on here? This is language that gives that owner the remedy against the builder in the case of the unpaid sub. But you're saying I don't have to limit it to that. It could also apply in this case if you were to the overpaid sub who then is expected to give a kickback at some point.
Right. It could, yes. And so the act basically establishes that, and it's like with any trust fund, right? If money is provided to a trustee, the trust has to use it for trust purposes. And so here for construction project purposes. And what are those purposes? Well, one of them is not to steal the money, which we would argue happened here. And so that's what happened here through this kickback scheme is this money is considered a trust, held in trust. One of the beneficiaries is the owner. And when Falcon used this money for, among other things, enriching themselves in ways that are not authorized by the contract and not authorized by any disclosure provided to the owners, that is a violation of both Michigan Builders Contract Fund Act and a violation of their fiduciary duties and its conversion. And so beyond just violating the contract, breaching the contract, they also violated their fiduciary duties and the Michigan Builders Contract Fund Act. And there's ample case law support for that too, where under many different scenarios where a trustee holds money for certain purposes and they divert it for other purposes, that a conversion claim can lie there, and the courts are clear also that conversion, and contract claims can coexist as long as there are independent duties that are alleged to exist apart from the contract. And that's even in the authority, that the case law that defendants cite. Those same cases hold that conversion claims can coexist with breach of contract claims, and it's in the statute itself, to the conversion statute. The specific provision is MCL 600.2919A2, which provides that the remedy provided by this section is in addition to any other right or remedy the person may have at law or otherwise. And so the statutory conversion statute makes clear that the remedy it provides for conversion can exist in addition to a contractual right for recovery. And again, the case law bears that out, to the Deponio case we cite, which is a construction case, provides that a contractor's duties under the Michigan Builders Contract Fund Act are independent of and in addition to the contractor's obligations under its contract. And so plaintiff's conversion claim, in this case, their conversion claims are grounded in defendant's independent breach of their fiduciary and statutory duties under the Contract Fund Act, and also their duty not to convert the project funds that the defendants held in trust. And so,
very good. Yeah, let me flip and hear Mr. Hill's argument on the issue of conversion. Mr. Hills, you may be muted.
What the plaintiffs are asking the court to do, Your Honor, is to ignore the particular substance of the Builders Trust Fund Act. And the court noted the very typical prime example most people are aware of who've had any dealing with the construction industry is owner makes a payment to a contractor, and some period of time later, suddenly there's a lien recorded by a subcontractor or a supplier saying, I never got my money. And that triggers an awful lot of scurrying around in a scenario where the general contractor then has to justify why it accepted payment from the owner and didn't pay the particular subcontractor or supplier. And I suspect this court's familiar with the fact that usually where there's one unpaid, there are multiples unpaid. That typically tends to be how it goes.
Sure. Well, and I guess important for this case, it appears that, the imposition of that higher standard, if you will, on the general to be a fiduciary and in effect a trustee under the Builders Trust Fund Act, makes this different than, otherwise, another hand-to-hand transaction where, say, I hand over a check and someone sells me a refrigerator. Well, then undoubtedly, I'm not just saying, hey, hold on to this a check for me. I want you to do X, Y, Z down the road, but rather, there's a one-for-one exchange. And I'd agree in that case, that check goes into their account and becomes their property. But I think Mr. Hoffman's saying, the language, how do I break out or reconcile that under the Builders Trust Fund Act?
Well, I'm glad the court asked the question that way, because the fallacy with the argument advanced by plaintiffs is that trust, under their view, exists forever. That there is at no point when that trust is no longer in existence, even under the plain terms of the statute. And so we do have to look at MCL 570.152, because it's within those specific provisions that we gain the understanding of what the intent of the act is. And the very specific intent is that the funds must be held in trust until, or the language used in the statute is for any other purpose than to first pay labor, subcontractors, material men. So the issue here, Judge, is at what point in time does that trust end? And I posit to the court that based on the plain language of the statute and the cases we cited interpreting it, once all subcontractors, suppliers, and material men are paid, the trust terminates because there is no longer a basis for an owner to say to, under this statute, for an owner to say to a general contractor, you've now somehow misapplied the funds in the context of this act, which is, again, very specifically designed to protect those individuals. And again, if we look further then into section 152, it is a standard of, and we put this in bold in our reply brief on page 1, the other language of the statute that's very pertinent is that it applies while any amounts for which he may become liable or become liable under the terms of his contract for such labor or materials remains unpaid. That is a factual scenario that the plaintiffs cannot satisfy. All the subs, all the suppliers, all the material men have been paid in full. No liens on the project. Nobody's asking for payment. Once that occurs, there is no longer a trust to be had because the very specific provisions of this statutorily imposed trust have been at that point satisfied. And that brings us back then to the court's comment, which is then the claim as it relates to the other funds sounds in breach of contract, which is a pending claim in this case, or fraud, which is a pending claim in this case. And that being the case, there cannot be conversion because as to those particular funds, they were tendered by a negotiable instrument. And keep in mind, Your Honor, because the court's example or hypothetical to Mr. Hoffman was, well, we have this situation, right, where we might have an overpayment to a subcontractor pursuant to this alleged scheme or fraud. The statute does not address overpayments. It very specifically says in section 152, it applies while any amounts for which he might become liable, he might be liable or become liable still remain. That can't be met because there are no amounts owed to subs, suppliers, or material men for which Mr. Lemon, actually his trust, that's another issue we're going to deal with in a moment, I know, could become liable. They've all been paid. If you accept the plaintiff's view of this, that trust continues forever. There's no argument by plaintiffs that there is then some point temporally at which the trust expires. The test for whether the trust, for when the trust expires is at what point is it that the payor is no longer liable or potentially liable for these sub-suppliers and material men. And we are already past that point. There's no evidence in front of this court that any subcontractor, supplier, or material person is not paid. If that's the case, which it is, then there is no trust that still remains. And
Okay.
the funds that were paid to Falcon pursuant to negotiable instruments then are not properly the subject of a conversion claim. They're the subject of a fraud claim. They're the subject of a breach of contract claim. They might be subject of some sort of a separate breach of fiduciary duty, but under the specific language of the statute, which this court must apply as written, that trust has expired.
Okay. All right. Let me turn back to Mr. Hoffman for a response on section 152. Does that operate, in a case like this where there isn't a claim, at least that I'm aware of, by any sub against Falcon or the Lemons, then cut off, the cause of action sufficiently that, the conversion claim wouldn't lie?
Sure. And Your Honor, I'll just note for the record that this argument that Mr. Hills is making right now on the trust terminated was not briefed. And I would be happy to address that argument right now in oral argument, but it wasn't briefed. And so I don't have the citations to the specific cases that I would love to mention because I have briefed it before in other cases. But the fact of the matter is courts have rejected that argument that this trust terminates once everybody's been paid, because here's the absurd result that it can lead to. Say, for example, a general contractor receives $100,000 from an owner for a project, and say that instead of hiring the 5 subs they need to hire, that instead the general contractor only hires 1 and pays that subcontractor in full. But now he's got $80,000 left over that he was supposed to use for other subcontractors, but he never contracted with them, never ended up retaining them. And so he washes his hands, the general contractor does, and says, no fiduciary duty here anymore. The trust is terminated because all subs that I ever hired were paid, and I can keep the 80,000, and the Michigan Builders Contract Fund Act does not apply, and I'm not a fiduciary anymore. And so the courts have said that's the absurd result that would be reached here if the legal theory and the argument that Mr. Hills is making was actually adopted by the courts, and it hasn't been. The fact of the matter is that this trust does continue, and because there are still, if there are disputes that are related under the construction project on how payments were allocated, those can be resolved under the Michigan Builders Contract Fund Act and the fiduciary duties that the contractor still has to the owner. They continue, and to the extent, and it wouldn't continue for forever, because that's what statute of limitations are for. But that's not an argument that's been made, nor could be made in this case either. And beyond that, Your Honor, I think it really ultimately this whole argument doesn't necessarily matter under for purposes of the conversion claim, because there's no question, and I don't hear Mr. Hills disputing it, that Falcon had fiduciary duties. And they had fiduciary duties at a minimum, at least Mr. Hills is saying, during the time of the project. And that's when we say the conversion happened. So whether the trust, terminated after that or not, the trust was there during the project. No one disputes that. And fiduciary duties existed during the project, and that's when this conversion happened. And so whether that was under the Builders Contract Fund Act, whether it was their independent fiduciary duties that they had, those fiduciary duties existed, and those provide for an independent basis apart from the contract for a conversion claim to lie.
Okay. All right. No, I think I understand both sides.
Well, final word,
Yeah.
Your Honor.
Yeah, go ahead, Mr. Hills.
Relative to this hypothetical that counsel just proffered to the court, under that concept, there would be work that was incomplete because the contractor didn't hire enough subs to do all of the work. What counsel said was there was work that should be done by 4 or 5 subs. He only hires one, pays that one in full, and therefore
he gets a 4x4 shed and said you thought you were getting 2,200 feet, but really you're getting the she shed on your lot. There it is, and then the question of could the action be brought? It seems like it could be brought against the general in that case, that he didn't act properly under the act by hiring the adequate number of subs and should return that money. Or do you disagree that he wouldn't have at least that cause of action? He'd have to proceed under something else.
Well, he'd have to proceed under something else, but more importantly, under that hypothetical is factually inapplicable to this scenario. There is no suggestion in this case that the home was not constructed using all necessary subcontractors, suppliers, material providers, etc. So to suggest that there's this odd scenario that could apply,
there's
someone doesn't retain enough subcontractors, just is not factually accurate relative to this project. The project was built according to specifications provided by an independent architect hired by the Lemons. And no one has ever suggested that there were some significant portions of those specifications that weren't constructed. They may contend that something wasn't constructed correctly, but there's no suggestion that there should have been some additional group of subcontractors or suppliers involved. The argument just doesn't make sense in the context of the situation that actually occurred here.
Okay. Well, as I said, this, presents an interesting intersection of the law of conversion, both statutory and common law, and the Michigan Builders Construction Fund Act, which I think I got right that time in terms of what those initials stand for. And what's before the court today is the question of whether or not those conversion claims can withstand summary disposition. And the arguments advanced against that are, Judge, they are, first of all, not valid because once a check is written and payable to Falcon, that then becomes the property of Falcon, and ergo can't be converted any more than, I could go back to the Maytag after I sent them the check and they gave me the refrigerator. No matter how much I disliked my refrigerator, I got something for my money, and I couldn't go back and say, you converted my money, by selling me the lousy refrigerator. And however, unfortunately, and I think that is where the Builders Trust Fund Act does intervene, because obviously it anticipates a building contract where there is an ongoing relationship between a general contractor, subcontractors, and of course the owner, who is writing the checks, and ultimately is the individual most protected by the builders. It's going to kill me by the end here. The Michigan builders, boy, who's help me out here? Is this
It's generally the Trust Fund Act. That's
the Trust Fund Act? I know it's probably known by. Well, that's what I am trying to say here is the Michigan Builders Trust Fund Act. In effect, at the end of the day, it's the owner who's protected, and the mechanism that the law uses to impose that protection is it creates a statement of a trust, that being the money paid to the general, but known by both the owner and the general contractor to be utilized to pay subcontractors, while it's in the hands of the general, held in trust for the payment of the subs. They're entitled to some protection here, and of course for the protection of the owner, because it's anticipated to be utilized for exactly that purpose. And I believe that broader interpretation of the the Trust Fund Act, even though interestingly it doesn't say Trust Fund Act, but it uses the trust language and the fiduciary duty language, or the act imposes that type of language, and so that's something we as attorneys are familiar with. Clearly wants the general contractor to have that fiduciary duty, and it does run, as most fiduciary duties do, to the owner as well. And so certainly in a case like this, where there are alleged to have been overpayments made by the owner to the general, and then overpayments passed on by mutual agreement, apparently by the general, the sub billed at a higher amount than they invoiced for initially, or might have invoiced for. They marked it up, and then at the end of the year, after some period of time, returned that money. There certainly is an argument, and ultimately probably the argument that will be made at trial in this case is that money should have been, under that same fiduciary duty, returned to the benefit of the owner. That should have been at least a consideration for the builder in the instant case. And thus, the argument that it's either subsumed by the contract clause, well, the contract law of contract doesn't impose that fiduciary duty. Of course, it does require strict compliance with the contract, but not fiduciary duty, and neither does the law of fraud require that. It simply requires that you not lie or falsify information that the other party relies upon. But the Builders Trust Fund Act clearly imposes a higher duty here, and that higher duty could support, under the best facts seen in the best case for the plaintiffs in this case, a conversion cause of action, either under statutory or common law conversion. And I will deny the motion to dismiss those claims at this time. We'll move on to the next count. Well, Mr. Hills, why don't you direct me to your Second argument. Is this Lori Lemon? Can she?
Well,
can
no,
she
Your
be
Honor.
the
Actually, the
real
next
party in
argument,
interest?
the next argument is the real party and interest argument, Your Honor.
Yep.
And we have this situation where there is no dispute that the Lemons personally never paid a penny for any of this, that all of the funds were paid from a trust in which we know with the provision of it as part of the response. Clearly, Miss Lemon has no interest whatsoever. She is not a settlor. She's not a beneficiary. She's not an identified trustee. So certainly,
Certainly might be a third-party beneficiary of it, I suppose. Although I'm uncertain, and anytime I say trust, I think the first instinct in my mind is to ship the case to Judge Murkowski and crew, because that's their area of expertise. Although I think in this case, it certainly illustrates a case where a trial court might be called to interpret trust law. But wouldn't she have a potential role, as argued by the response here, as a third-party beneficiary?
I disagree wholeheartedly, Your Honor, because the third-party beneficiary argument they make is that not as a trustee. That's in respect to the fact that she is not a party to the contract. She didn't sign the contract. So we're kind of jumbling arguments. If
Sure.
that's what the court wants to do,
right.
we can
I see
happily
what
do
you're
that.
saying. Yeah.
So the third-party beneficiary argument advanced by plaintiffs is not in response to the real party and interest. It's in response to the third argument we make, which is that she simply did not sign the contract, acknowledges in her deposition that she never considered herself to be a party to the contract, has no ownership interest in the property as confirmed by Mr. Lemon's deposition, and therefore has no ability to make any of these claims. The third party
when you say no
beneficiary,
interest in the property, you mean her name's not on the
correct. She has
deed.
no ownership in the property. Okay. She's essentially an occupant of the property. That's the total of her interest in this. She happens to live there by virtue of her marriage to Mr. Lemon. She doesn't own any portion of the property. She didn't sign the contract, and her own testimony is she didn't believe that she was a party to the contract. So the third-party beneficiary response to that argument fails for this reason, Your Honor. It cites the third-party beneficiary statute, which is very particular. And what that statute says is if you are the intended beneficiary of a contract between two other people, you have an independent right to assert that second contract. Here, in the typical circumstance for a homeowner, the homeowner would say, I was the intended beneficiary of a contract between the general contractor and the subcontractor, which allows me to directly sue the subcontractor, even though I did not have a direct contract with the subcontractor. That is not the circumstance here. It is clear plaintiffs have never sued any subcontractor in this case. That is the only application of the intended third-party beneficiary statute that could apply, but does not apply. It's being proffered to you as justification for a direct suit by Ms. Lemon against the general contractor. It's just entirely outside the terms of the statute. So let's go back to the real party and interest argument, Judge. And I'm going to hearken the court back to its determination relative to the construction deposit and its determination that Falcon had not proffered sufficient evidence here today to withstand the motion for summary disposition. And I would suggest to the court strongly that the plaintiffs have not proffered any legal authority to this court to demonstrate that they are real parties in interest. The entire response of the plaintiffs to that argument is to rely on two statutes and cases that interpret those two statutes, which by their plain and unambiguous terms provide relief for creditors, specifically seeking to recover assets or funds that have been deposited into a trust in order to avoid collection in a claim against an individual. And that law clearly does not apply here. There is nothing in those statutes or those cases that addresses the real property and interest issue at all. by way of response from plaintiffs. And the simple fact of the matter is, all of the funds came from a trust, and there is no inclusion of the trust or any individual as trustee in this action. So those funds.
What about his reliance on the trust language itself, where it says, well, after all, Todd Lemon at any point can dissolve. He has the entire as the trust. He's both. I mean, that's the nature, of course, of a self-settled trust is that what do you call that guy who pays the money into the trust to
The
start it
settlor.
up? The settlor. He's the settlor. He's the trustee, and the beneficiary occupies, in effect, all the seats in the room. I think I've heard it referred to as an individual moving his roll of $20 bills from one pocket to another. What's the difference? I mean,
The
in
difference
terms of the trust language.
Well, in the terms of the trust language, I have not tried to interpret Mr. Lemon's trust, Your Honor. It does not, whether the trust provides him with the ability to do those things have never happened.
Well, but he didn't contract as Todd Lemon trustee. He contracted as Todd Lemon. And then, so I mean, the argument here is, well, the money came from the trust. And presumably, if there was damage done here, the argument might be made that, in a different trust situation, perhaps that the trust needs to be made whole rather than Mr. Lemon. In this instance where the law makes subtle or little differentiation between Mr. Lemon and his revocable trust, why would that have an impact on the, I guess on the identification of the parties in this lawsuit?
I disagree, Your Honor. I think the court rules make a very specific delineation. They say you actually have to have
the name of the. Yeah, I understand.
You actually have to bring the name in the suit of the interested party, and the interested party in this situation is the trust. Mr. Lemon wrote no check out of an account belonging to Todd Lemon. He certainly didn't write any check out of an account belonging to Todd and Lori Lemon. Lori Lemon doesn't have the ability to make any sort of a determination regarding the trust, as this court just sort of alluded to a few minutes ago. So I don't believe, respectfully, Your Honor, it is an accurate statement to say the law draws little or no distinction in this regard. I think the Michigan court rules draw a very specific distinction.
Well, when I'm looking at these checks, and I do see they all are, do reflect a trust instrument, and part of that is, one of the unique things about identifying a trust is they sometimes, identify it by date as well as the name of the trust. So, and I'm going to go to the first one here just for ease of reference. So I'm at, let's see, this is your exhibit. Yeah, this is tab 1, wire and check payments, and I'm at that first check, which is check number 108 from the Todd A. Lemon Trust, 0203 2010, paid to the order of Falcon Custom Homes, an amount there $47,439.75, drawn from the bank Goldman Sachs and Co. LLC, and presumably is that Mr. Lemon's signature, or is that another trustee's signature?
We believe it's. I believe, Your Honor, because these checks were usually signed and handed directly to a Falcon employee, that I can represent that is Mr. Lemon's signature.
Okay.
It's his. It's his.
So I mean,
Your Honor, so the
presumably as trustee.
Right. So the distinction the law recognizes is that there is an action in representative capacity, but that has not been put into this lawsuit. We cannot simply ignore that existence in the requirement of the court rules.
Okay.
Well, that's the real party and interest argument, to which there is no legal response by the plaintiffs other than to say, well, there's this statute that allows creditors to penetrate through a trust to an individual, and the court should apply that by analogy. But that's just not simply the status of the law.
All right. Well, let me hear from Mr. Hoffman on, let's lead off with the trust argument and then go to the Lori Lemon argument.
Thank you, Your Honor.
Just to be clear, Your Honor, I didn't mean to suggest by just the Lori Lemon argument.
Oh,
I still
okay.
view,
No, I didn't mean to cut you off either, Mr. Although I am also watching and fully aware that I started this hearing belatedly due to my own schedule. I also have another matter that I'm intruding upon at the moment, but I do want to address all the parties' arguments, and if the other one needs to get bumped, I would allow that because this is important to get through it. So go ahead, Mr. Hills, on Lori Lemon.
well, as to Lori Lemon, again, I'm going to try not to repeat myself too much. It's a clear situation where Miss Lemon did not sign the contract and has very expressly stated in her deposition, including during efforts to rehabilitate her on this issue, that she did not consider herself to be a party to the contract. And the law in Michigan is quite clear. Cited this in the reply brief. If there is no intent to be bound by the contract, there is no contract. That's her testimony. That's what the document demonstrates, regardless of who it identifies on its face sheet as the parties. She didn't sign it, and she doesn't think she's a party to it. So she has no right to enforce anything that relates to the contract. The other aspect of this thing, Your Honor, I think that bears out then is it also, in conjunction with the fact that she has no ownership in the property itself, she is merely an occupant of the property, and that doesn't give her the right to advance any of these claims. And I'll rely on the briefing to cover the rest of it because I appreciate the court is under some time constraints.
Yeah, it seemingly is always, unfortunately. So, all right. Well, let me go to Mr. Hoffman. Mr. Hoffman, why don't you take the trust question first and Lori Lemon second?
Yep. Thank you, Your Honor. On the trust argument, the statute that we cite and quote in our response, MCL 556.128, provides that when a grantor retains an unqualified power of revocation, as Mr. Lemon did here, and this is the statutory language I'll quote, he is thereafter deemed still to be the absolute owner of the estate conveyed so far as the rights of his creditors and purchasers are concerned. And so the statute is clear that he is the absolute owner of the funds in this case. I think the plain language of that statute stating that the grantor here, Todd Lemon, is the absolute owner of the estate conveyed, that establishes that there is, for practical purposes, no difference here between the trust and between Mr. Lemon individually. And I'll point something else out to the court. Defendants are trying to create this distinction here and saying that, the real party who was damaged here and who made the payments here is the trust and not Todd Lemon. Well, you'd think that when they bring a claim for amounts they say are still owed, that, they would follow their own argument and bring the claim against the trust. Well, in the separate action they filed, who do they sue? Mr. Lemon individually, not the trust. And so I think it's ironic that they didn't bring their claims in this separate action against the trust, while at the same time arguing here to the court that, the only party who's been damaged here is really, the trust and not Mr. Lemon. And the cases we cite, Your Honor, they make clear that, this inter vivos fully revocable trust that's really can be compared, it's to a bank account. And so whether Mr. Lemon took the funds out of one bank account to pay for Falcon, or took them out of a different bank account to pay Falcon, or whether he took them out of his right pocket or his left pocket, or wherever he took the money from, I think it really is, Your Honor, they're just making distinctions and differences where there really are none. Ultimately, the money, according to the statute in the case law, belongs to Mr. Lemon, and that's who paid it here.
Okay, why don't you take up Lori Lemon?
On Lori Lemon, Your Honor, the contracts express language, page number 1, and identifies both Todd and Lori as owners, quote unquote. The signature block.
Absent her signature, isn't that kind of a nullity or just I mean, not a nullity, but certainly her signature. I mean, contracts frequently name a
Your
lot of
Honor,
people.
if you look at the contract, the signature block, it also has a provision for owners. And I know the S is in parentheses, so it could be an owner who signs it or owners, plural, who signs it. And given the contract provides that both the first page in defining who's the owner, it defines it as Todd and Lori Lemon, and the signature block has the signature for owner or owners. And so that signature that Todd put there is on behalf of who's identified in the contract as owner, and that's Todd and Lori Lemon. And the course of dealing confirms this. We've attached numerous emails, contemporaneous, while this project was ongoing, where defendants, they always treated both Todd and Lori as parties to the contract and as the owner, as the customer. They always stated that in their emails. They said, we're building this house for Todd and Lori Lemon. We want to make sure we get this done right for both of you, Todd and Lori Lemon. And so the course of dealing and the contractual language supports it. And the fact that, the defendant's counsel presented this legal argument to Miss Lemon, during her deposition and asked her if she signed the contract and is she a party to the contract? And just because a person may say, I'm not a party to the contract doesn't mean it's so. If a party could go and, while the contract defines them as a party, then say in litigation, no, I'm actually not a party. I mean, that it obviously can't be the law. And so that isn't here either. And one other thing I'd point out, Your Honor, defendant's answer to our first amended complaint. Here's a couple quotes from that. Paragraph 10. Defendants admit only that Exhibit A is a copy of the construction-only cost-plus agreement between plaintiffs, plural, and Falcon Custom Homes, Inc. Paragraph 17 through 18, same thing. They talk about the plaintiffs as being the parties to the contract. And paragraph 30, same thing. And the Lemons both Lemons receiving the invoices, the Lemons paying Falcon under the contract. And so I think this is an argument they made up during this litigation, and it's contradicted by their own contract, which they drafted and should be construed against them. And it's contradicted by their own answer, which is also binding on them. And finally, the sworn statement that we attached, Your Honor, they also, in this sworn statement, which Mr. Abbott signed under criminal penalties, he also defined the Lemons, both Todd and Lori, as owners there as well.
Did you attach that sworn statement as one of your exhibits?
Yes, we did, Your Honor, and I do not have the exact. We attached a lot of exhibits.
I noted that.
Yeah, and it's not. I don't know exactly the which exhibit number it is, but it is attached. And I know we attached it to our motion, our partial motion brief as well.
Another question, Mr. Hoffman. Say I say that while she's not a proper party to the contract claim, does that knock her out, or does she still stay a party under the non-contract related claims that you've pled?
Absolutely. She still does stay under the non-contract claims that we have pled as well. The Michigan Contract Fund Act, it creates fiduciary duties that run to those for whose benefit the construction funds are held, not only the contractual counterparty. Here, the defendants, they held the funds in trust for the construction of the home intended for both Todd and Lori Lemon. That's, again, confirmed by the contract, confirmed by their own communications, by their sworn statement, by their answer. And the fraud claim as well, the argument, again, is a contractual argument by defendants there. But, of course, a fraud claim is that is based on a misrepresentation inducing someone to rely on that misrepresentation. And the misrepresentations here were made to both Todd and Lori. She relied on it just as much as Todd relied on it, and she was damaged by that. And so that's the essence of the fraud claim. And it doesn't matter, even if the court would hold that she's not a party to the contract, which again, we think that's at best a factual question, unsuitable for summary disposition. But even so, the fraud claim is still independent of that because she was misrepresented facts as well, and the negligence too. Defendants argue that she can't establish standing because it relates to a home in which she has no interest. She is living in this home and was living in this home, and the defective workmanship that is the subject of the negligence claim obviously affects her in a home that she lives in every day. And so I don't see any scenario under how she does not have a cognizable negligence claim here, given, the water that's dripping through the roof is dripping on her just as much as it's dripping on Todd. And Falcon owed duties to her just as much as they owed them to Todd, because they knew all along she was going to be living in this home just like Todd was living in this home. And the dangerous conditions that they have created, through the glass that's falling, the water pipe that blew a hole in their basement, that's all affecting Lori just as much as it is affecting Todd.
Okay. Yeah, no, I think I understand.
I'd like to reply.
Yeah, no, I would welcome you to do so, Mr. Hills.
Your Honor, if you look at those two statutory provisions, it is clear from their plain and ambiguous language that they were enacted by the Michigan legislature specifically to protect creditors from the ability of someone to defraud them and hide assets or protect assets from collection efforts.
Sure. What about the purchasers? I'm struggling there. Okay,
it doesn't change the analysis in any way, shape, or form. The situation we're talking about here is the real party in interest requirement under the Michigan court rules. Whether it's a creditor or a purchaser doesn't change the fact that that statute does not apply in this situation and this legal analysis. It is carved out specifically to protect people who are trying to collect money from the beneficiary or settler of the trust. The reverse is what is going on in this situation. The trustee, not in his trustee capacity, but in his individual capacity, is trying to collect money. It's the entire 180-degree opposite scenario. And if you look at the cases that were cited by plaintiffs, it's within that factual scenario that they apply the statute, where someone is trying to hide assets in a trust. That's why those provisions were enacted. They are not meant to have some general application to say that in every situation, a trust is the same as the trustee.
No,
So
right. That would
argue
kind
that-
of negate the value of a trust entirely.
Again, that's whether it's creditor or purchaser, those are both 180 degrees opposite. That's where someone's coming back to the trust or trying to get, frankly, the settlor or the beneficiary, who then scurries and tries to, as you just alluded to in that scenario, veil or hide it by putting it through the trust. Here, the trust is not the subject of any claim. The trust is the claimant. And those statutes, by their plain terms, don't apply.
Got it. No, I think I do understand the argument that you're making.
As to Miss Lemon, Your Honor, I find these arguments puzzling, to say the best. But for example, Your Honor, during our long discussion about the Builders Trust Fund, counsel pointed out that the Builders Trust Fund is there to protect suppliers, subcontractors, materialmen, and owners. Miss Lemon is not an owner. She owns no interest in the property. She cannot satisfy the statutory definition of an owner because she doesn't own anything relative to the home. So, for instance, to the extent the court would suggest, well, she would have standing as to those claims. She doesn't have a standing as to a builder's trust fund claim. She doesn't own anything separate from the issue of the money at issue in both the conversion and the builder's trust funds claims came from a trust in which she has no interest whatsoever. She's not a trustee. She's not a settlor. She's not an identified beneficiary. No interest, period. So that claim cannot apply. Fraud cannot apply. You have to rely to your detriment. Miss Lemon is not an owner of the property and has no ownership interest in the money that was paid. She has suffered nothing detrimental relative to any allegation of fraud. It's
What
a
about
necessary.
Mr. Hoffman's very concrete example of, well, if water's dripping from a leaky roof onto my head and I'm living in the house, I've suffered. Is that's incorrect in a legal sense, is what you're saying?
Absolutely, Your Honor, because how was she relying detrimentally on some representation about a water pipe? First of all, no representation was made to her about a water pipe. The fraud aspect of this relates not to construction defects or some aspect of negligence. It's to the allegation that Falcon suggested to Mr. Lemon a whole variety of things, and he relied to his detriment by giving them money that then went to this scheme that he continues to call it. It doesn't relate to the fact that water might be dripping on her head.
Well, they have
That
a
can't be
negligent construction claim, and I guess it would fall under that category too, right? Isn't there that a component of the complaint?
Well, I guess the court would have to find that as an occupant alone of the home, that's her only interest, that Falcon owed her some duty. She's not a party to the contract. We know that. And I'll get to that in a second relative to that argument. But what is the duty specifically that Falcon owed her as someone who happens to live in the house? I posit that as a rhetorical question.
Yeah, no, I get what you're saying. Just like we now, look at in a premises claim or something
Yes.
along those lines, there has to be some duty owed by the right.
Correct.
Right. One part.
And last, Your Honor, again, the only thing that matters with respect to Lori Lemon in the contract is what did Lori Lemon intend? Doesn't matter whether she was referred to in the document generically. It doesn't matter whether she was referred to in a pleading generically. Again, if you look at the deposition testimony, not only an answer to my questions, but an answer to Mr. Hoffman's questions, she expressly said, I did not intend to be a party to that contract. That's it. Period. End of story.
Now, does it do you any good to say she's not a party to the contract claim? And I'm visualizing this verdict form someday we give to a jury, and it says, "Well, folks, you only signed the contract claim vis-a-vis Todd Lemon, but maybe the fraud or the negligence for Todd and Lori Lemon." I guess I'm also struggling a bit here to see what either party, because I guess that same question could go back to Mr. Hoffman. Well, if I say Lori Lemon's not a party to any of it. It seems like Todd Lemon can still make a claim for the breadth of the relief he's asking for, and that on the flip side of it, if I mix those claims together, well, it's going to look a bit confusing there as to why she's on some and not on the others. What are your thoughts on writ broadly? What difference does it make?
Well, I would suggest to the court that the ultimate difference it makes is what the law provides for. If there is practical difficulty in how you set up the format of a jury verdict form, that takes clear second seat to the fact that someone is not allowed to continue to be a named party on claims to which they have no right to pursue. This isn't a function of, well, what's good for the goose is good for the gander. This is a function of what does the law provide? And we're not going to simply allow her to coattail along because her husband can bring claims that she otherwise isn't allowed to be a party to. Because, again, by her own statements, she never intended to be a party to the contract.
No, that certainly does appear to be the case, and one can certainly envision a scenario where she wouldn't want to be a party. For example, if the shoe, the kind of polarities were reversed here, and this beautiful home had been constructed, and then, by the way, Mr. Lemon, you never paid a dime. That then we're going to pursue you for it. Well, then I wouldn't want to be Lori Lemon and say, oh, by the way, Lori, you're on that contract too. You're responsible. One can see where she might, not want to be, part and parcel of that contract for those purposes. So let me give Mr. Hoffman one more opportunity to weigh in on, what's your thought on this idea of, well, she's party for some of the claims, but not for others?
Number one, Your Honor, and I think the contract itself makes clear she is a party to the contract, and defendants have confirmed that through their course of dealing. And
even if she doesn't sign and later, in her deposition, it denies any intent to be a party.
I would disagree with the way that defendants have framed what she said in her deposition. Again, I think they asked her a legal conclusion in her deposition, and she's not an attorney. And that was her testimony there, and she wasn't, even understanding fully what they were asking for her. They were asking her for a legal conclusion. Are you a party to a contract? I mean, how is a layperson who has, no legal education supposed to answer that? And someone who's not in this business either. She's not in the construction business. And so
I understand she could have misapprehended, but nonetheless, I mean, I also can see protections she gets, benefits she gets from not being a party. I mean, like, as I said, if the shoe were on the other foot, and there was a massive unpaid bill due to Falcon, she might indeed want to say, that was all Todd's deal. I wasn't in on that. I mean, she would get some benefit from that.
Right, Your Honor. It could be that she could get some benefit from it, but I think the way this was drafted, and which again has to be construed against defendant because they drafted the contract, and also the course of dealing here, which also the court should consider in interpreting this contract, at a minimum creates a question of fact on that, because the defendants clearly treated her as a party. Why else were they including her in all the communications? Why else were they asking her, do we do this way? Do we do this that way? Why were they communicating with her on fixing the workmanship issues? Why were they communicating with her about payment under the contract? They clearly always saw her as a customer, as a co-owner here with Mr. Lemon.
And so, of course, the dealing is something that I can look at is when there's an ambiguity. You're saying the naming of the two, but signature by only one creates the ambiguity. And judge, therefore, you should look to course of dealing as well as intent of the party, and don't put too much weight on her intent because, this was a legally worded question to her that perhaps she wasn't, able to, answer. Certainly as an attorney, but also, with full understanding. So I think I understand the argument. All right. Well, go ahead.
Your Honor, the contract is the contract. The court looks at the four corners of the document before it goes anywhere outside of the document.
Well, the four corners have her name in it, right? I mean, it does say this.
But she didn't sign it.
Yeah, but she doesn't
sign it.
Yeah.
And this is her response to Mr. Hoffman's question about whether she was a party to the question. Line 12 through 15, page 32 of her deposition. In response to Mr. Hoffman's question, I didn't sign anything, so I'm not sure if I'm a party of it because my name's on there or not. As far as I know, I wasn't a part of the contract because I never signed anything. That's her intent. There's no need to go to some sort of secondary or tertiary sources to determine the issue. One, she didn't sign it. Two, she says I'm not a party to it. That's the end of the discussion. This whole course of dealing is an absolute red herring to distract this court from the two hard, cold truths. She's not a party to the contract, and she never thought she was.
All right. Well, I realize these are points upon which thoughtful minds could probably disagree, but ultimately my job is to come to some resolution of it. So, with regard to the involvement of Lori Lemon, since that's the issue that's we've most recently been discussing, she is identified, of course, as a co-plaintiff in the action. And is notably present, presumably then, a co-plaintiff as to all the claims made against Falcon and Nathan Abbott. And, problematically, claim number one is one of a breach of contract. When the contract is examined, as defendant accurately points out in this case, though the contract does name and this is I'm referencing exhibit number one of plaintiff's response brief in this matter. In fact, it is conveniently, however, it's base numbered here as Lemon 000000325. In it is the cover page, and it says construction only, cost plus contract. The builder is Falcon Custom Homes, Inc., with its license number and address, and the owners identified there as Todd and Lori Lemon. However, when one turns to the final page of said contract, the builder is signed, apparently Falcon Custom Homes, Inc., by Nathan Abbott. However, the owner/S is signed apparently only in this case by Mr. Todd Lemon. That's consistent with the deposition testimony in which Miss Lori Lemon says, I don't think I signed, so I don't think I'm a party to the contract. I.e., she, at least, at very least, did not recall, she confirming that, there was, for some reason, she did not sign the contract, and she did not recall. This isn't a mistake, in other words, where we're missing a page. It is, for whatever reason, only signed by Mr. Todd Lemon. Now, those two, the presence of both of their names on page one, but only one signature under the same exact title, owner or owners, on the signature page, do create, as far as the court's concerned, an ambiguity here within the contract, allowing the court to go beyond the four corners of the contract for interpretation. Now, part of that has to be, well, what was the signing party's intent? Miss Lori Lemon, she said, I don't think I signed that, and thus, I at least don't think I'm bound with it. Now, she's not super clear that she never intended to be a part of the signature, or that she was doing this because this was Todd's project, or because, she had some other interest there. She is just clear that it was intentional, that she did not sign the contract. And also to be considered in that analysis, or potentially considered, and I think appropriate in this case, is the course of dealing of the parties. Who was there at what times relevant between the parties? Miss Lori Lemon unquestionably, was present throughout the execution of the contract and present. So I believe that creates at least a fact question as to whether or not Lori Lemon was a party to the contract in this matter. That fact question, as to her, the appropriateness of her being a party, may also exist as to other potential claims, but it's most clearly present there in the contract claim. So I will deny the motion for summary disposition that would, in effect, knock Lori Lemon off the masthead of this case and keep her on, her participation being a fact question to be determined by a jury at trial. Secondarily, there is the question of the real party in interest with regard to Todd Lemon, who did sign this contract undoubtedly here as Todd Lemon, and of course wrote multiple checks to Falcon that he signed in his name, Todd Lemon. However, those checks were drawn on an entity referred to as the Todd A. Lemon Trust, and referring to, and I'll try to get this narrowed down here. I guess that check I've been referring to and did refer to previously, check number 108. This one is attached to the defendant's motion for summary disposition as an exhibit. Indicates a check drawn on an account from Goldman Sachs and Co. LLC from the Todd A. Lemon Trust dated 2/3/2010, dated 5/8, and the instrument is dated 5/8/21, to Falcon Custom Homes in the amount of $47,439.75. One of many checks written to Falcon and identified as coming from, as perhaps the the name on the account is the Todd A. Lemon Trust, creating a question that I think is fair to bring before the court. Well, is Mr. Todd Lemon, the individual, the correct party in interest here, or is it the Todd A. Lemon Trust? Now, in response to that, the plaintiffs have provided a restated trust document that defines this particular trust, and it is a unique type of trust. And of course, trusts, like contracts, are entirely dependent on their language, and this one is one that would be known in the legal vernacular as a self-settled revocable inter vivos trust, established September 10th, 1993, and restated on February 3rd, 2010. And specifically, the trust agreement provides here that grantor may revoke the trust or may amend his trust agreement at any time, and that upon revocation, trustee shall transfer to grantor, which is of course himself, or as grantor shall direct in the instrument of revocation the trust property, that referring to Article 2 of the trust, and further provides that the trustee shall pay for, to the benefit of grantor, so much of the net income and principal as grantor may request or as grantor may otherwise direct, and that grantor reserves the right at all times to remove property from the trust property, to make gifts, and to deal with the trust property without accounting to any other person or trustee. Now, trusts, of course, are dealt with, at least to a degree, by Michigan law, and Michigan law does provide some sections that refer to this self-settled trust, and that being MCL 556.128, which says when the grantor in a conveyance reserves to himself an unqualified power of revocation, unquestionably here, he is thereafter deemed still to be the absolute owner of the estate conveyed, so far as the rights of his creditors and purchasers are concerned. So this obviously is a provision of Michigan law that says statutorily, when one is dealing with a trust, and I guess the relevantly situated party here would be perhaps I'm not even going to extend this to Falcon because that's a poor example. I gave an example earlier during oral argument about me conveying a car, and if I did it in trust, that's where a purchaser could need some protection from someone operating under a self-settled trust. But that doesn't, of course, directly apply to the situation here where the trust itself provided all the money, certainly, for the construction of this house. Does that mean the trust itself needs to be the real party in interest, or is the true party in interest the settlor, trustee, and a beneficiary of all the money that's in that trust, Mr. Todd Lemon? And I will find, for purposes of today's argument, because of the nature of that trust and the specific language of that trust reserving all trust powers of note to Todd Lemon, that he is simply another name for the Todd Lemon trust that's cited on those documents, and that for purposes of this lawsuit and the financial questions raised therein, that there simply is no distinction that matters at law with regard to Mr. Lemon's drawing upon funds held in the name of his trust or issuing those funds personally that impacts his standing as a real party in interest in this case. As I said earlier, I think that the analogy of Mr. Lemon switching a stack of money from one pocket to another is relevant for purposes of this, and that that money, then if it's used to pay Falcon, whether it came from his left pocket or his right pocket, in this instance, the revocable trust or him individually, was unimportant for the purpose of what happened during this case. So Todd Lemon may remain as the real party in interest, and that motion to remove him as the real party in interest is denied. All right. Thank you, gentlemen. Mr. Hoffman, I think you prevailed today. So are you going to write me a draft order on this?
Yes, Your Honor. Thank you.
Reference the record so the Court of Appeals can curse me as they wish as they go ahead and review the record someday in the future. So I appreciate everyone's arguments as asserted today, and the well briefed as well. Thank you.
Thank you, Your Honor.
Your Honor. Good weekend.
You as
Have a
well.
good weekend.
360K, that's the deposit, gotta pay it back. Builders, lawyers looking sloppy, saying we ain't doing that. Judge asks where's the invoice for the Jenner, we ain't doing that. The kickback scheme, the phantom bills, a wheeled machine. Tried to say the wife can't sue. Now that's a legal smoke screen. Judge Rossi saw the whole charade. From the pockets to the trust, left the builders desperate, loopholes turning into dust. Motion denied.